After you've received a notice, if you haven't fixed the problem or if the time expires for a 14-day notice or a 30-day notice, the next thing that will happen is that the landlord can choose to go to small claims court. When the landlord goes to small claims court, they have to file, which is going to cost $94.50. That goes up every few years, so that could increase just a little bit. But the landlord pays $94.50 to file an eviction. At that point, that eviction is on your record. When you look up in CCAP, which is the Circuit Court Access Program, any landlord throughout Wisconsin is going to be able to see that you've had an eviction filed against you. If you win, that information will always also be in there, but you want to make sure that any landlords that you talk to in the future realize that you did not get evicted and that you don't in fact have an eviction on your record. Landlords can sometimes be confused by that information or don't look all the way through to see that information. Once the landlord files, like I said, then it'll be on your record, and at that point, then they have to serve you a notice. The previous notices we talked about just have to be served, and as long as you receive them, it's sort of generally going to be accepted by the court. These notices, there's a very specific process that needs to be followed, so they need to hire a civil process server or someone who is experienced in serving these types of notices. When they get done serving the notice, they sign an affidavit going back to the court saying that that person was served. And they cannot be served by the landlord or somebody who works for them. It has to be somebody that they hire as a third party. Once you receive that notice, the court will schedule a court date. So after you receive the notice, you'll have at least 5 days before a court date is scheduled. And again, 5 days is counted without the weekends and without holidays. When you first go to court, your first court date is going to be called a joinder conference. They may call it a pretrial conference or a joinder conference or something different in your county. But that first court date is basically meant to determine if there is grounds to go to trial. Oftentimes in some counties, after they determine that, the very next thing that happens just minutes later is you do go to trial. If either party wanted to contest that, if they wanted to have more time to bring in paperwork or get witnesses, they could request that the court give a trial on a different date, and the court would have to give a trial on a different date. At the joinder conference, typically what might happen is if the landlord and the tenant can come to an agreement, they may enter into a stipulated dismissal. What a stipulated dismissal is it says that each of the parties agrees that the rent will be paid on a certain date, and if those deadlines and requirements are met of what that agreement is, then the case will get dismissed and the person will not get evicted. So if you owe $500 and you show up to court and you have $400 and you're promising to pay $100 on Friday, if the landlord accepts that payment plan, you'll enter into stipulated dismissal. As long as you make that payment on Friday, your case will get dismissed. If you cannot work out an agreement, then the next thing that happens is that you go to trial. Trials in different counties can be very different. Some are held before a court commissioner and are very informal. Others are held in a courtroom with a regular judge. So if you're going to be going to eviction court, we usually recommend that you go to your courthouse and maybe watch a few. Typically, they're all scheduled at the same day or the same time of day, same day of the week. And at that point, you can go and you can watch trials. They're open to anybody, and you can learn a little bit about the judge and what they'll be looking for. If the landlord wins at trial, the next step is that the court issues a written order. That written order is called a writ of restitution. That writ of restitution is a piece of paper that the landlord then takes over to the sheriff's department, and the sheriff's department then is in charge of removing the person from the property. If the tenant wins during the eviction process, then nothing happens. Everybody goes back to the way things were before, and the tenant can continue to live in the apartment. One of the new provisions is that it used to be required that the sheriff's department would be there when the landlord was removing the property. Now, if it's written into your lease that the landlord can remove your property without the sheriff, that step is no longer necessary. So the sheriff may or may not be present when your property gets removed from your apartment. Typically, when the sheriff comes out to remove you from the apartment, they will leave a notice on the door. The notice will either say that they'll be back on Wednesday at 9 o'clock or you have 24 hours to be out. When you get that type of a notice, it's really important that you get out before that sheriff's department gets there, because any belongings that you may have in the apartment will be difficult to get back at that point. Sometimes the first notice you get about the eviction process is when the sheriff puts a notice on your door. If that happens, you can go back to small claims court and ask to have your case reopened. Sometimes something happens in the service process where you don't get notified of the court date, and without proper notification, the case can be reopened and you have the opportunity to have a trial before a judge if you didn't get properly notified. After the sheriff has removed you from the apartment, there is a possibility that you'll still have to go back to court. Oftentimes, the court schedules a second hearing later on after the full eviction process has occurred to determine how much money is owed to the landlord. So at that point, the landlord can go back and figure out how much money it costs to move your items, how much the sheriff's department costs, and how much rent or money is owed, or any type of other damages that are done to the apartment. At that point, there will be a second trial. So it's important that you give the court your forwarding address so that they know how to contact you and you get notification of that court date. Otherwise, if the landlord says that you owe $6,000 and you're not there to contest it, that will end up on your record, and you'll have to pay that amount or ask to have the case reopened to redetermine how much money is actually owed.